So welcome back, members. So we are doing the trial advocacy 2015 paper where we are reviewing question and answer directly. So I'll be brief and direct to the point. So if you look question one, the question one was basically testing one on adherence to cross-examination and how the same can be done effectively. And then if you look at part B, it was giving a student a question that wanted an outline of the critical rules or warnings regarding what an advocate must not do in re-examination. That is a very critical angle of looking at it. So if we begin with cross-examination has been provided for under section 146(2) of the Evidence Act, where the cross-examination must relate to relevant facts and need not be confined to what was covered in examination in chief. Then in cross-examination, you can ask leading questions pursuant to section 151 of the Evidence Act, and then prior inconsistent statements, you may cross-examine on prior written statements to contradict. You must put the relevant parts to the witness first. This is pursuant to section 153 of the Evidence Act. So basically, if you are asked about the rules, we can say that the rules are being provided under sections 146 all the way to section 153 of the Evidence Act. And one rule is that you refer to relevant facts, and you can ask leading questions, and you can cross-examine on prior written statements. Okay, then another key takeaway that you can have is that we have seen decisions that say that cross-examination is broad and may test credibility beyond the witness statement so long as it is relevant. Then cross-examination can extend to any previous written statements, as we have discussed. Okay. Then, what are the critical rules and warnings that an advocate must not do in re-examination? In re-examination, you cannot ask leading questions. This is pursuant to section 150 of the Evidence Act, unless the court will permit you to do so. Okay. Then re-examination must be directed to explaining matters referred in cross-examination. If new matter is introduced with the court's permission, the other side may further cross-examine on it. Okay. So outline the don'ts clearly. So don't introduce new issues that were not raised in cross-examination, pursuant to section 146. Don't try to repair your case generally inside a re-examination. Then don't ask leading questions unless the court permits so under section 150. Then don't reopen credibility attacks on the opposing case. Okay, don't invite long narratives. Re-examination should be short, targeted, and limited to removing confusion created on cross-examination. Don't use re-examination to ambush with documents and lines that were not put across on cross-examination. And don't over-explain. The more you roam, the more openings you create for further cross-examination and submissions that your witness was coached. Those are the marking points that the examiner was expecting to see. Question number 2. Generally, this is an excerpt that was taken from the Golden Rules of Advocacy, page 51. Do you agree with the proposition above, that an advocate's job is to lead his or her fact finder to a preference and thus to an opinion? So I agreed with that context, in that most Kenyan trial, the fact finder rarely catches a liar. The outcome usually turns on which version is more credible or probable under the governing standard of proof. A trial advocate's core job is therefore to restructure, test, and explain evidence so the court rationally prefers your theory without misleading the court. There are some governing rules that will support this answer. If you look at section 154, section 153, and section 163 of the Evidence Act, credibility is tested through cross-examination and impeachment tools. The Evidence Act expressly allows cross-examination aimed at a witness's accuracy, veracity, and credibility, and permits impeachment by inconsistent prior statements, bribery or corrupt inducement, or evidence that the witness is unworthy of credit. Okay. So the Evidence Act has expressly allowed cross-examination aimed at a witness' accuracy, veracity, credibility, and permits impeachment by inconsistent prior statements. That is one angle where you can seek for impeachment of a witness, where there are bribery or corruption inducements, or evidence that the witness is unworthy of credit. Then The other governing rule, we have Section 55 of the Advocate Act and Section 56 of the same Act, where the advocates are officers of the court and disciplinable for in-court misconduct. Your position must stay inside professional or ethical limits. The court retains power to deal with advocate misconduct in proceedings. Okay, so have a look at various judicial interpretations. Credibility and demeanor matters, and the judicial officer who sees or hears witnesses is best placed to assess it. Where a successor magistrate proceeds without seeing key witnesses, the trial can be rendered unfair or unsatisfactory because credibility assessment is central. Okay, what are the answers to the question? Do you agree with this proposition? And discuss the role of a trial advocate in court and indicate aspects of the psychology of advocacy that are critical in trial advocacy. So those are the nitty-gritties that a student ought to extract from the question. Okay, let's start with the role of the trial advocate in court. Case theory and selection. This reduces messy facts into a coherent narrative aligned to the legal elements. Decide what to concede, what to contest, and what to ignore. Most cases are won by disciplined selection, not encyclopedic coverage. So one role of a trial advocacy in court is to have a good case theory and selection of the relevant facts. Then proof control. Ensure admissibility, foundation, and sequencing of evidence. Anticipate objections and clean evidentiary weak points early. Okay, that is another role of the trial advocate. You have proof of control of your matter. Okay. Cognitive load. Judges and magistrates manage high case loads. The advocate who reduces complexity wins. Use timelines, simple themes, and repetition of the same theory. That is another marking point. Have a structured theme and timeline and reduce complexity so you become as simple to understand. Then confirmation bias and coherence. Fact finders prefer internally coherent stories. Your theory must explain the awkward facts better than the opponents, otherwise the court will fill gaps against you. So that is another duty of a trial advocate. Have confirmation bias and coherence. Credibility. Courts use shortcuts when it comes to consistency over time, admissions against interest, documentary anchors, independent corroboration, and realistic human behavior. Cross-examination should target these behaviors and not insults. Okay, so the court will test the credibility. So it is the duty of the trial advocate to test the credibility behaviors. Demeanor limits. Courts acknowledge demeanor, but it is fallible. Over-reliance on gotcha theories often backfires. Use contradiction and probabilities more than aggression. So the other duty is to have a demeanor aspect, a demeanor control of your matter. Then fairness. Respective tone, measured pacing, and apparent fairness increase perceived reliability on your entire case theory. Do you have a respective tone before the court? That is a duty of the trial advocate. Anchoring. First credible number of facts in damages or quantum or sentencing mitigation, e.g. becomes a better reference point. Anchor early with principled support, not arbitrary figures. Okay, so the other key point that the examiner was testing was on so we have witness management. This is an ethical point. This will fall under the aspect of psychology, the psychological expectations of a trial advocate. You should have a witness management skills. Examination in chief. Elicit facts that support your case theory with clarity and chronological logic. Cross-examination, where you use Evidence Act, credibility tools, especially prior inconsistent statements and internal inconsistency, will reduce reliability of adverse testimony without insults. On re-examination, repair only what matters, don't reopen damage. assist the court as an officer of the court on the accurate law, fair characterization of evidence, clear issues for determination, and candid concessions where unavoidable. Okay, courts can sanction for in court misconduct pursuant to section 55 and 56 of the Advocates Act. So those are the various aspects of the psychology of advocacy that are critical in trial advocacy. Okay. So basically we have answered the question. Tabu has been having a land dispute with his brother Bravo since the death of their father. The protracted dispute led the village elders to mediate between the two brothers on several occasions. Unknown to them, Tabu was not satisfied with the outcome of the mediation and still remained bitter with his brother. One evening, while leaving his local club after a couple of drinks, Tabu bumped into his brother. A war of words ensued, and Tabu attacked his brother with a big stone from the roadside and left him for the dead. Bravo died after getting to the hospital, and Tabu has approached you to represent him in the matter. Against the above facts, discuss any 5 basic UN principles of the role of lawyers. So this is testing about the international applicable laws when it comes to the role of advocates. Okay. So basically, there are at least 5 clean UN basic principles you must observe in taking Tabu's brief, even for a serious homicide. They boil down to access to counsel, where you have the application scenario is where you ensure immediate appearance. Confirm plea taking is not done without advice, and secure disclosure or time to prepare. This is where you prepare witness statements, postmortem skin, and extracts etc. Then independence of the legal profession. This is another principle laid down by the UN. A UN basic principles. Independence of the legal profession. Principle is that lawyers must be able to act freely and independently without intimidation, improper influence, or interference. The application is that if the police or prosecution attempts to pressure you, e.g. withdrawing the defense, or don't raise bond, you document and challenge it in court. You take instructions from Tabu, not the village or elders or family dynamics. That is principle number 1. Principle number 2, we have confidentiality and legal professional privilege, where all communication and consultations between the lawyer and client are confidential. Okay, professional confidentiality is expressly recognized in statute, pursuant to Access to Information Act, as an example. So the application to the fact is that Tabu admissions about motive or anger or land dispute or drinking is privileged. Then another principle, we have competence, diligence, and promptness. Lawyers must maintain professional competence, act diligently, and protect the client's interest. These are likely murder or manslaughter contest. Okay. Duty to uphold human rights and the proper administration of justice. In defending a client, a lawyer must uphold the law and ethics. Representation does not equal endorsement of the offense. You defend Tabu robustly, okay, because you have the duty to uphold human rights and proper administration of justice. So there are other acceptable UN principles you can also use. You have freedom of expression or association for lawyers. You have protection of lawyers from prosecution or harassment for professional acts. Then you have fair disciplinary procedures. Then special safeguards for lawyers facing threats. Okay. So remember section 6(1) of the Access to Information Act exempts disclosure that will infringe professional confidentiality. Access to Information Act, pursuant to section 6. Then the UN Basic Principles of the Role of Lawyers, 1990, are soft law, but are commonly taught or used in international standards. Okay, so those are the 5 basic principles: access to a lawyer or legal aid, independence of the legal profession, confidentiality and legal professional privilege, competence, diligence, and promptness, duty to uphold human rights, then protection of lawyers from prosecution, fair disciplinary procedures, and special safeguards for lawyers facing threats. And then one of our own acts, section 6 of the Access to Information Act, exempts disclosure that will infringe professional privilege. Explain your critical duties to the court in the circumstances and explain your professional duties to your client under the circumstances. So we have answered. 3. Your client, Mr. Bob Awendo, walked into Goldest Jewelry Silo one morning. He had been shopping around for an engagement ring. He was very excited about his plans that Alan to propose was proposing to for her to be his fiancée. No sooner had he walked into the shop than a smartly dressed gentleman walked in and also began looking at the beautiful rings on the display. The next thing Bob heard was a gunshot followed by orders for everyone to lie down. He noted that the smart gentleman was part of the gang. The robbery took barely 5 minutes. In the midst of the confusion, Bob managed to leave the shop only to be arrested outside the King Bay. Askari at the door identified him as part of the gang. Bob, pleas about having nothing to do with the robbery fell on deaf ears. He has been charged with robbery with violence and his family has asked him to present Bob. Prepare an opening statement for trial. Outline and discuss 10 elements and ingredients of an opening statement. That is a very critical question and I had omitted it unknowingly. So I will return when we will be discussing our second session and come to the trial advocacy. I must undertake to answer that question because opening statements are mandatory when it comes to trial advocacy and the elements of and ingredients of the same is critical. The other question, Jen bought a parcel of land in Kitengela from Kamau. At a consideration of 150,000 to complete the transaction, the parties got into a sale agreement prepared by Masha Imba Advocates. Upon the execution of the agreement, the funds were transferred to Kamau's bank and the title deed was handed over to Jane. 2 years down the road, Jane decided to sell the land so as to get fees to pursue her master's degree. At this point, trouble began. She visited the land office and discovered that she had been conned. The land was actually registered into the name of Abdallah. She sues Abdallah for the refund of her money. Acting as Jane's lawyer, you have prepared for the trial. Set out 1, 5 good facts, then 5, then a theory for your case. 15 marks. Okay. So Jane's strongest trial posture is a straightforward Nemodat plus misrepresentation case. Kamau sold what he did not own, received the full price and must refund the 150,000 plus interest and cost. The hard part is the evidential gap on due diligence and the absence of these facts of proving Abdallah's registration to Kamau's fraud. Okay. 5 good facts to help Jane. Written sale agreement prepared by an advocate. Okay. Supports the existence and validity of the contract and formalities. These are the relevant facts to help Jane. Purchase price paid in full and traceable. Funds transferred to Kamau's bank. This is a strong proof of consideration and receipt. The immediately delivery of the title deed to Jane. Conduct consistent with the representation that Kamau had title and capacity to sell. Then 4, Jane only discovered the problem at the land office later. This supports she was not complicit. Also supports limitation and discovery arguments if raised. Then current lands office records show the land registered to Abdallah and not Kamau. This supports the co-breach, failure to pass good title, and Nemodat. Those are the 5 good facts. So the examiner expecting a student to know how to extract facts from a case. Then are you in a position to extract the bad facts from a situation? So no evidence. Jane did an official search before paying. The 2-year delay before discovering the fraud. The title deed was handed over but registration remained with Abdallah. Suggests the document could be fake or irrelevant and raises authenticity issues Jane must prove. Abdallah was the registered proprietor. Is not said to be joined. If Jane later seeks title or rectification, non-joinder becomes fatal even for fraud for refund. It limits fraud narrative unless tied to Kamau. Okay. Facts are silent on land control board consent or transfer instruments and stamp duty on registration steps. So defense may argue that the transaction was incomplete and unenforceable beyond refund. Also creates gaps in Jane's diligence story. Theory of the case. Okay. Case theory, how is it drafted? So Kamau induced Jane to pay 150,000 by representing he was selling her a specific Kitengela parcel and had authority and title to transfer it. Jane fully performed or paid, and Kamau received and kept the money, but he could not pass the title because the land was and remained registered in Abdullah's name. This is a fundamental breach and misrepresentation. The constitution was had totally failed, so the court should order restitution, a refund of 150,000 plus interest from payment and cost. So from a case theory, you can say that you give the brief facts and in a summarized manner, and plus you finish over with some of the orders that you seek the court to grant you. Okay. So that the practical trial focus. You prove contract. Okay. Produce the signed attested agreement plus advocates and witnesses, prove payment, prove impossibility of conveyance, prove reliance and innocence, and bring them to the remedy. Those are the practical trial focus that you have to implement in your case theory application. Question 6. Onyango is married with 2 children. The marriage does not seem to be working. And the wife Judy ran away from the matrimonial home 6 months ago with the kids. She immediately filed a suit in the children's court where she intends to obtain orders that Onyango should maintain the children at 200,000 per month. During the trial, Onyango had filed an affidavit of means in court, swearing that she did not have a stable, she only had an income of only 100,000 and a mortgage for the matrimonial home at 50,000. So Judy has instructed you to file for divorce and a suit to dispute the matrimonial property. During chief examination, Onyango surprisingly states in his evidence that he pays 100,000 per month while Judy pays nothing, and that she is not entitled to a share of the matrimonial home. Assuming you are cross-examining, you assume now you are cross-examining Onyango. What is the statutory foundation for impeachment? Then give at least 3 ways in which you can impeach Onyango's evidence, and 3, what are the steps and elements of impeachment that you will invoke? So impeach Onyango by 1, attacking his credibility using prior inconsistent statements and documents. Then B, demonstrating undisclosed income or assets, so the court rejects his 100,000 net or affidavit of means. The Evidence Act gives you the statutory routes and the confront and then prove method. So statutory foundation for impeachment of a witness. Okay, this is under Evidence Act Cap 8. Evidence to impeach credit of a witness. This is pursuant to Section 163 of the Evidence Act. Cross-examination on previous written statements, Section 153 of the Evidence Act. Cross-examination as to credibility, veracity, and accuracy, Section 154. Court's discretion on questions affecting credit, Section 157 of the Evidence Act. And reasonable grounds requirement, pursuant to Section 158. If income or assets are especially within Onyango's knowledge, pursuant to the affidavit of means. Okay, this is pursuant to Section 112 of the Evidence Act. So as a key takeaway, whenever we will encounter a situation where we are told to give statutory foundation for impeachment of a witness, we have the answers. We have the answers. Section 163, this is the enabling provision. Evidence to impeach credit of a witness. Where you have evidence to impeach the credit of a witness, that is a statutory foundation for impeachment. 2, where you are cross-examining on previous written statements if there is inconsistency. This is another angle of impeachment. Then cross-examination as to credibility on veracity and accuracy, Section 154. And court's discretion on questions affecting credibility. This is also another foundation for impeachment. The court can use its own discretion. And reasonable grounds a requirement, pursuant to Section 158. So if there are reasonable grounds for the court to impeach this witness, it can. And if some evidence were especially within the witness's knowledge, pursuant to Section 112, then at least 3 ways you can impeach Onyango. 5 marks. Under Section 163(1), of the Evidence Act. You can impeach an angle by 1. Prior inconsistent statements, be it written or oral, e.g., compare the affidavit of means with bank statements, pay slips, tax returns, loan applications, SACCO, prior maintenance filings, and employer letters. Okay, then you follow the procedure that has been laid down in section 153 of the Evidence Act. Then number 2, calling independent witnesses to say he is unworthy of credit. This is why you are attacking his reputation or opinion evidence. So in this situation, because Onyango is saying that he does not have any credible means, so you have already attacked him, you have already impeached, you have already challenged his credibility on prior inconsistent statements by the affidavit of means, because you now have documentary evidence to counter that. Then the other angle is where you call independent witnesses to attack his reputation and opinion evidence, where you call the employer or payroll officer and bank and relationship managers and accountants, pursuant to section 163(1). Then you can prove bribery or corrupt inducement to shape testimony. This is rare in children matters but examinable. So if evidence shows he had paid someone to generate fake payslip and letters, this can be used as a ground for impeachment of a witness. Section 163(1)(b), okay, of the Evidence Act. Plus, generally, you may ask credibility testing questions under Section 154 of the Evidence Act, subject to the court's control under Section 157 all the way to 158. Those are the marking schemes that the examiner was expecting to see a candidate applying. Okay. Okay, then steps and elements of impeachment you will invoke. So commit him to impeachment by prior inconsistent statements. So commit him to the present position on oath. Confirm you saw your net income is 100,000. Yes, you lock the testimony. 2. Confront him with the specific inconsistent material. Do you know this document? When is it dated? Kindly read paragraph dash. Kindly read that figure. Okay? Because if it's a written prior statement, you must call his attention to the exact parts you will rely on before proving it, pursuant to section 153 of the Evidence Act. Then you give him a chance to admit, deny, or explain. If he admits, credibility is damaged and move to quantify means. If he denies or evades, proceed to prove. Prove the inconsistency with admissible evidence. Produce the document via a proper marker or custodian. Okay? The bank officer, the employer, KRA records, or otherwise lay foundation for production. Tie it to credit and relief sought. Submit that his affidavit was false and misleading. Invite the court to reject it and assess maintenance of the true means. Then the other angle that you can use, so because you have used step number 1, you can use impeachment by prior and consistent statements. Then the other angle, you can use special knowledge burden, because he had a special knowledge pursuant to section 112 of the Evidence Act that he had an income stream and business receipts and assets and loan servicing were peculiarly within his knowledge. Then section 112 shift the evidential burden to him to make full disclosure once you raise a credible basis. Okay. So, synthesis and practical cross-examination plan. Confirm the affidavit is his, sworn date, and that he intended the court to rely on it. Then lock in the claimed net income and the stated expense. Put to him specific lifestyle or asset indicators. Then confront him with the documents showing higher inflows or undisclosed assets. Then after denial, call custodial witnesses to produce and authenticate the records, argue section 163 plus section 112 of the Evidence Act. The next question, question 7. After a long year murder, 3-year murder trial, where you are representing either the DPP or the accused, you have been asked to prepare a closing statement for the DPP and the accused. Ensure that in your submissions you bring out at least 5 key elements or ingredients of a good closing statement. You remember there is a question that I said that I will answer. So in this paper, 2015 paper, the question on closing statement appeared regardless of whether the same question had been asked in the same paper. Okay, so a good murder trial closing must 1. State the legal test and pardon. Set out the elements of murder. Marshal the evidence element by element. Confront weaknesses and credibility issues and end with a clear lawful order sought. Is it conviction or acquittal or alternative verdict? So what you must anchor the closing on: elements of murder, unlawful causing of death with malice aforethought, section 203 of the Penal Code. Malice aforethought indicators: do you have intent to kill or cause grievous harm, person section 206 of the Penal Code. Then murder sentence provision, section 204. Okay. Prosecution must prove fact or cause of death plus accused unlawful act and malice aforethought and beyond reasonable doubt. So generally, how did the examiner expect a student to draft a closing statement for the DPP as asked in the question? Okay, because you have said the elements. The elements are there before you. Legal test. Set out the element. Then element by element. Confront weaknesses and credibility and end with a clear and lawful order being sought. Do you seek conviction, acquittal, or alternative verdict? That was granting 7 marks. How can you structure a good closing statement for the DPP? May it please the court 1 mark. The prosecution asks for a conviction for murder. The law is clear that under section 203 as read together with section 206, we must prove beyond reasonable doubt that the deceased is dead and the cause of death, and that the death was unlawfully caused, and that the accused caused it. And 4, the accused acted with malice aforethought. Okay. 1. Death and cause of death are proved. The postmortem evidence is uncontroverted and aligns with the injuries described by the eyewitnesses. 2. The act was unlawful. There was no lawful justification on the record that excuses the killing. Then 3. Identification and participation is proved. The prosecution witnesses consistently placed the accused at the scene and described his actions. The defense did not shake their core narrative in cross-examination. Any minor inconsistencies are not material and do not dislodge the central facts. So malice aforethought is proved by inference from the nature of the weapon, the targeted body part, the force used, and the conduct before and after the attack. The only reasonable inference is intention to cause death or grievous harm within section 206. So generally, whenever you are told to draft a closing statement, if the statement is to apply for murder charges, these are the marking points. Proof of the death. The act was unlawful. Identification or participation is proved, and malice aforethought is proved by inference. Okay. Question 8. Mrs. Kuwachana has filed a divorce petition against her husband of 10 years, Mr. Kuleo, on the ground of cruelty. In the particulars of cruelty, she alleges that the husband is extremely violent, abusive, and that he has threatened to throw her out of the matrimonial home. She did not set report the accidents to the local police station. She did report the incident to the local police station. She obtained an OB number bearing a medical report which showed severe burnt blunt objects inflicted soft tissue injuries all over her body. You have been instructed by Mr. Kulwa to defend the petition. What are the 5 key rules of cross-examination you will apply? 5 marks. Draft at least 10 questions in cross-examination around the cruelty allegations. And then identify 5 key rules of cross-examination. 1. We are answering what are the 5 key rules of cross-examination, 5 marks. Ask leading questions, 1 fact per question. Cross-examination is properly done by leading questions. You suggest the answer. This is pursuant to section 151 of the Evidence Act. Leading questions may be asked in cross-examination. Then section 149 of the Evidence Act provides for what a leading question is. Then 2. Keep it relevant and purposeful. You are intending to attack credibility, accuracy, and bias, or show inconsistency. Okay. Cross-examination must relate to relevant facts, but its scope is wide. Pursuant to section 146. And the purpose or width of cross-examination was decided in Republic versus Patrick Oita Nyapara. Then put your case to the witness on disputed points. If you later argue she is lying or mistaken or injuries came from elsewhere, threat didn't happen, confront her with that proposition in cross, fairness and credibility testing. So you put your case to the witness on disputed points. Do not ask open-ended questions. Never let the witness retell their story. Avoid why, how, what happened unless you want narrative. 5. Do not be abusive, needlessly offensive. Maintain court control. The court can forbid insulting or annoying questions. So that is also another rule of cross-examination. Ask leading questions. Keep the questions relevant and purposeful. Do you want to establish credibility, accuracy, or bias or inconsistency? Put your case to the witness on disputed points. Do not ask open-ended questions. Do not be abusive in cross-examination. Draft at least 10 questions for cross-examination in this situation. Okay. You cannot tell the court the exact date of the first alleged assault, can you? You have your cross-examination questions should be on narrow perspective, where you are testing the date and places, test credibility and inconsistencies, separate threat from actual violence, probe the police or OB or medical chain, and suggest an alternative explanation where available. Okay. Cross-examination should be controlled. We have discussed that to the best of our knowledge. Question 9. This is the last one because the next week, not next week, tomorrow we'll be tackling conveyancing 2015. So the last question reads that 9. In fact, question 9 was borrowed from criminal litigation, and because the question happened to have found itself inside my research works, so I decided that I'll not exclude it. So number 9 that appeared in that question paper, because we still have a look at it. What is the statutory foundation for contempt proceedings in Kenya? What are the powers vested in the Supreme Court judges to deal with contempt of court? And give the steps you will adopt in handling an exhibit in court during trial to ensure that it is admitted without any objections being raised by your opponent. If you look at the trial advocacy cause outline, we still have a contempt of court proceedings in Kenya. Okay, so luckily it is still under trial advocacy. So statutory foundation for contempt proceedings in Kenya. Contempt proceedings in Kenya are principally grounded on Section 5 of the Judicature Act, which imports the applicable English law procedure on contempt. Remember, that this question was also asked last year in professional ethics paper on an advocate who was found to be abusive before the Supreme Court of Kenya. Okay, so governing rules that you must take note of is that Section 5 of the Judicature Act confers power on the High Court and Court of Appeal, and by extension superior courts as court of record, to punish for contempt and ties the applicable procedure and substantive approach to the English position as adopted through the Judicature Act. Contempt of Court Act 2016. Although it appears in the statute's database, Section 5 courts have held that the Act was nullified, and practice reverted to Section 5 of the Judicature Act. So status affected by nullification decisions. So there is a decision that declared Contempt of Court Act unconstitutional. So courts apply Section 5 of the Judicature Act after nullification of the Contempt of Court Act pursuant to Mokua versus Central Kenya Conference of the Seventh-day Adventist and another 2023 decision. So Section 5 of the Judicature Act imports English procedure. Kenyan proceedings adapt to local practice. So what are the powers vested in the Supreme Court judges to deal with contempt of court proceedings? Okay. So practically, Supreme Court contempt control also manifestly appears through case management and disciplinary control of the advocates appearing before it. Okay. So what the Supreme Court judges can do, can cite and punish persons for willful disobedience of the Supreme Court orders, can deal summarily with contempt in the face of the court while still observing minimum fairness where punishment is penal. They can also issue coercive and penal sanctions, e.g. committal and fines, while the legal threshold is met, and control the court record and process, including expunging offensive pleadings and submissions, and directing apologies or referring and triggering disciplinary consequences for the advocates. That is what the judges can do. Okay. Steps to handle an exhibit in trial so that it is admitted without objection. This tests now the power or the ability of a student to know how to produce an exhibit before court when it comes to trial. Okay. So, pre-trial disclosure. List the document or object in your bundle and list and bundle of documents and serve them in time. Ensure the opposing side has a clean copy of it. Relevance and purpose. Be clear in your notes what fact in issue the exhibit proves and through which witnesses. Okay. Authenticity foundation. Through a competent witness. Remember, if you want to produce a document before court, call the maker or custodian or a witness who can properly identify it, what it is, how it was made or obtained, and that it is the same item or document. Avoid mysterious documents with no sponsoring witnesses. And then integrity chain or custody. Record where it was kept, who handled it, when transferred, and how tampering is excluded. For digital evidence, you take note of that. You use electronic certificate of production, certificate of electronic evidence production. Marking for identification, request it to be marked MF1 or court's equivalent practice before formal production if needed. Formally produce the exhibit through the witness. I wish to produce this as exhibit X. Ensure the exhibit number corresponds with your bundle index. So what guides you is how you labeled the same in your list and bundle of documents. So preempt common objections. Here say use the marker or custodian or fit it within an accepted exception. Eligibility and alteration, provide a clearer copy, certified copy, or explain alterations. Then keep a clean exhibit trail. That is it. Generally, the examiner wants to test whether you know that the first step is to draft a list and bundle of documents. You mark the same accordingly, you paginate the same. Then if there is an electronic document, do you know how to attach electronic documents? Do you know how to call for the documents that are in custody of the other side through a notice to produce? Okay, that is the test that is before the case management conference. Then do you know exactly how to mark the same during production? Do you know what the statement the witness will say before court? And you know that it is the maker or the custodian of the document that will produce the document? And lastly, do you know how to counter if that is a secondary document or it is a certified copy of the original? Okay, do you know those elements? As a trained trial advocate, give 10 trial techniques that you should invoke in court so that you always win your cases. What do you understand by appellate advocacy? 5 marks. Give 5 differences between trial advocacy and appellate advocacy. It's a prohibited serious professional impropriety. An advocate must not guarantee outcomes or create an unjustified expectation of cases. This statement is misleading because no counsel controls judicial discretion or evidence. It can amount to professional misconduct, or have doubting and inducement or false assurance to our client. Then it creates unreasonable client expectations and fuels fee disputes and complaints. Proper phrasing is to explain projects, risk, and litigation uncertainty, not certainty. Okay. Meaning of appellate advocacy. Appellate advocacy is persuasion in an appellate court, focused on identifying and arguing errors of law and, where allowed, errors of facts, based strictly on the trial record and the applicable standards of review to obtain a reversal or variation and affirmance. So what are the 5 differences between a trial advocacy versus appellate advocacy? So this is now a clear definition of what each entails. So trial advocacy proves facts. Appellate advocacy attacks or defends the legal correctness of the trial outcome using the existing record and standards of review. So you start with first differentiation. You have forum function. When it comes to trial advocacy, it is a fact-finding court where you test on witnesses and exhibits, while on the appeal. So if you use the appellate advocacy, when it comes to the forum, you use it as the appeal stage, where you have to look for error correcting court. For trial, it is fact-finding for the court. Then for appeal is error correcting court. You are correcting the same on law or record-based. See Section 78 of the Civil Procedure Act. Then the other head is evidence. In trial advocacy, you lead evidence through examination in chief, cross-examination, and exhibits. Then in appeal, you generally know fresh evidence confined to the record. Additional evidence is exceptional. Cause kill number 3. In trial advocacy, it is about witness control, credibility attacks, and evidentiary objections. In appeal, appellate advocacy, issue framing skills, statutory and case law analysis, standards of review, and record pinpointing. That is what is being tested here in court case. Then documents. In trial advocacy, we have pleadings, witness statements, exhibits, and lists and submissions. Then in appellate advocacy, we have memorandum in grounds of appeal, record of appeal, written submissions, authorities, bundle, and strict compliance with appellate rules. That is another differentiation. And lastly, we have scope of issues. You can plead and expand issues in trial advocacy angle because it's subject to procedure and built from factual theory. In the appellate advocacy, generally you cannot introduce new issues or amend trial pleadings to create a fresh case. Okay. So generally the examiner was testing a student from cramming. Okay. Because the examiner knows that this student has crammed on what amounts to trial advocacy. And the same examiner still knows that a student has crammed on what amounts to appellate advocacy. So for you to understand, you break down as shown before you. You start with the forum before the court. Appellate advocacy, it is error correcting. Okay, that is test number 1. That is test number 1. Appellate advocacy, error correcting. Trial advocacy, fact finding. Test number 2, evidence. In trial advocacy, you need evidence. In appellate advocacy, generally no fresh evidence. You are confined to the record, and additional evidence is exceptional. Then they also test on core skills. They test skills. Trial advocacy, witness control. Appellate advocacy, how you frame issues, case analysis. Then you go to the documents. Trial advocacy involves pleadings, witness statements, and exhibits. On the other hand, appellate advocacy, we have memorandum and grounds of appeal and record of appeal. Then scope of issues. In trial advocacy, you can plead and expand issues subject to procedures. Okay, you can plead and expand issues, but in appellate jurisdiction, you generally cannot introduce new issues, and that was granting a student 5 marks. So next, when we start, we'll be dealing with conveyancing. So generally, that was the breakdown of this paper, Trial Advocacy 2015 paper. That was a fair paper. Students should have scored to the maximum amount, to the maximum number of points available for this paper. Thank you so much for your attention.